Our panel is about the future of DEI, and we have a highly accomplished panel here. Professor Michael Frakes from Duke Law School, Craig Lean, who's formerly the director of OFCCP, now at K&L Gates, Obed Lussan, is that correct?
That's good.
Who's the chief people officer of Aptiv, Commissioner Andrea Lucas of the EOC, Professor Michael Yelnasky of Roger Williams Law School, and our commentator is Amy Traub from Baker Hostetler. Take it away.
Thank you. Can everybody hear me okay? All right. Well, we're at the tail end of the programming for today. We really appreciate you all being here. We are ending on an important topic, but we do recognize and acknowledge that we are the only thing standing between you and wine and cheese. So we will certainly do our best to keep within the timing. We have a very robust panel here of esteemed colleagues. So I will be commentating today, but my comments will likely be minimal given the great talent that we have here and all the people that would like to have a word on this. So we are talking today about the Students for Fair Admissions Supreme Court case from June 29th of 2023. We'll refer to this in the nickname that most people refer to it, which is SFFA. And what we are specifically talking about is how that decision has impacted diversity, equity, and inclusion, or DE&I, efforts, disparate impact claims, and Executive Order 11246. I'd like to briefly set the stage here with a quick review of the SFFA decision. I am mindful of the fact that there has already been a fabulous Supreme Court review panel as part of this program. It covers SFFA, so I won't spend too much time on the background. But very briefly, I think the four pillars of reasoning that SCOTUS used in arriving at this decision on June 29th are important to review as we talk about DE&I programming and efforts. So on June 29th, SCOTUS held that Harvard and the University of North Carolina had violated Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment, especially by giving preferences to minority applicants to assemble a diverse student body and reap the attendant educational benefits. The primary beneficiaries of those preferences were African American and Latinx applicants. In reaching that conclusion, the court effectively, although rather silently, I guess you could say, overruled its 2003 decision in Grutter versus Bollinger, which had held that the University of Michigan Law School could do exactly that. Now, as you likely heard in the Supreme Court panel, Harvard's and UNC's programs were found to lack sufficiently focused and measurable objectives warranting the use of race. The programs were found to unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. And I've paused in reciting each of those to you because those are, in fact, the four pillars of reasoning that came out of SFFA. So I want to break those down just a little bit further before I turn it over to our panelists to kind of walk through the implications of that reasoning and how it applies in corporate America, as well as to Executive Order 11246. So first, the goals of UNC and Harvard were found to lack sufficiently focused and measurable objectives that would warrant the use of race. Well, what were the goals? So the goals that Harvard and UNC articulated in wanting to give this preference to race in the admissions process were, we are training future leaders in the public and the private sectors. We're preparing graduates to adapt to an increasingly pluralistic society. And we are better educating our students through diversity. The court found that those were not sufficiently coherent to satisfy the high bar of strict scrutiny required for this kind of a program. Next, the college's programs were said to fail to articulate a meaningful connection between the means they employed and the goals they pursued. So, for example, the colleges actually lumped persons from the India-Pakistan region in with those from Japan and Korea under the category of Asian, resulting in what the court said was imprecision and a lack of connection to a truly diverse student body. Additionally, the admissions programs failed because they use race as a stereotype or as a negative. And lastly, the programs in place were said to lack any logical endpoint in time. So the court ultimately concluded that a student should be treated based on his or her experiences as an individual and not on the basis of race. So the notion that race could be considered preferably, or as some call it, a plus factor in the admissions process was done away with. Now, as we all know, what was not before the court and what was not decided in SFFA is whether and how, if ever, racial preferences can be used in employment. And that's what we're here to talk with you about today. Now, you'll hear from some of our panelists that the issue need not have been decided by the court because the law, as it pertains to employment-related preferences, had already been laid down for years. While other of our panelists might argue that the issue was less clear based on conflicting case law and other statutory interpretation. So a very natural place to begin this conversation, in my opinion, is with the EEOC. So today, we are very honored to have EEOC Commissioner Andrea Lucas with us. Commissioner Lucas, can you please share with us your thoughts on SFFA and the state of the law on all things DE&I, both before and after?
Well, thank you so much. It's a pleasure to be here at NYU and a pleasure to be on such a great panel. Before I get started, I have to give the usual disclaimer. As one commissioner on a 5-person leadership panel, I can't speak or bind the agency, except where I'm referencing existing EEOC precedent. But as it turns out, there actually is a fair amount of long-standing black-letter law in this space, as well as EEOC positions. I'll make that clear when I'm talking about that, when it's what the commission has said previously and what's my opinion, as much as I can. In terms of SSFA, the takeaway, in my opinion, is that, for purposes of today's panel, in SSFA, the Supreme Court just brought the university admissions standards into closer parallel with the long-standing, more restrictive standards of federal employment law. As I'm sure has been mentioned thus far today, the Civil Rights Act has 2 different sections, Title VII and Title VI. They are distinct, even if they have similar prohibitions and standards, and the court had previously analyzed them distinctly. And as has been mentioned previously in the university context, you were permitted to use diversity as a rationale, as a plus factor, as some component of decision making. As a Title VI case, SSFA, in my opinion, has no direct legal impact on the employment space. So, because it doesn't directly change the law, diversity, equity, inclusion programs that were legal before SSFA remain legal, and those that were illegal remain illegal. Now, whether or not that's good or bad news for any particular employer depends on whether or not the employer was complying with the pre-existing and continuing restrictive standards that apply to the use of race, sex, or other protected characteristics in employment decisions. So what are those standards? In my experience, most people, even sophisticated legal employers, have some really critical gaps in what the basic principles of Title VII requirements are, and a basic understanding of federal civil rights laws, and that leads to some common blind spots around DEI programs and policies, and in turn, legal risk. So to assess risk, to understand the state of the law, there's 5 straightforward things that I think that you need to understand. And each one of these points has significant wide-ranging implications across the board, as well as for DEI. And more importantly, and I think perhaps surprising for some people, I don't think these points are in dispute. I think these are generally well accepted, shared by all of the commission, supported by Supreme Court and commission policy. Where I differ, and it's my opinion, I'll try to specify that here. Okay, so point one, there is no such thing as reverse race or sex discrimination under civil rights laws. There's just discrimination. Different treatment based on race or sex is discrimination, no matter which group of employees is harmed or benefits. That's been the long-standing position of the EEOC and the Supreme Court. Title VII's protections universally, even-handedly apply to employees of all races and all sexes. Section 1981's protections apply to all races as well. Our civil rights laws and employment do not exclusively apply to quote-unquote historically underrepresented employees or whatever other categorization you might refer to that group of employees. They apply to everyone. Point two, in general, the default rule is that employers are not permitted to take any employment actions motivated by race or sex. That's also been the unquestionable rule for decades in employment law. Unlike the old rules in the university admissions space, in employment context, race or sex cannot be even a plus factor, a tiebreaker, or a tipping point. I find that people sometimes think that race or sex could be quote-unquote part of the equation for an employment decision, as long as race or sex isn't the sole factor, the exclusive factor, or the deciding factor. As I've said in other contexts, that's dead wrong. If race or sex was all or part of an employment decision, or a part of an employer's motivation, that violates federal employment law. And general business interests in diversity and equity, including operational benefits or whatever articulation you want on that space, also has never been deemed by the Supreme Court to be sufficient to allow race or sex-motivated employment actions. Indeed, Title VII's very limited carve-out for bona fide occupational qualifications, the BFOQ, only references religion, national origin, and sex. It excludes race. Prior to SSFA, some DEI advocates may have hoped that the Supreme Court would create yet another exception, maybe bless that kind of exception to the default rule against race or sex-motivated actions in employment law. But the Supreme Court's decision in SSFA slammed the door on that. That, I think, is the most direct legal ramification of SSFA. That exception is not going to be created. Point three, Title VII's protections don't just apply to current employees. They protect job applicants, interns, applicants for training programs, including on-the-job training programs. This is important because many race-conscious DEI programs are or were at the intern or the early career development stage of the employment life cycle. But that does not exempt those programs from Title VII coverage. And there's no question about that. That's a consistent position by the EEOC. Title VII extends broadly to that pre-employment stage, to that early career development stage. And point four, and this will bring in a recent Supreme Court case that some of you have heard about, Muldrow. And that's the point here is that the rules against taking against employers acting based on race or sex applies more than just hiring, firing, promotion, or demotion decisions, or other tangible, material, or ultimate employment decisions. There's been a variety of formulations in the circuit courts prior to Muldrow, but even before the Muldrow decision, the current position of the EEOC, DOJ, and 50% of the federal courts was that Title VII bars discrimination in all actions affecting, quote, terms, conditions, and privileges of employment, including actions that fall well short of hiring, firing, compensation, demotion, or promotion. So in the Muldrow decision, the Supreme Court effectively sides with the EEOC and DOJ's position. Again, this is a bipartisan position across multiple administrations. And it made clear that Title VII does not limit covered employment actions to actions that are, quote, unquote, materially adverse or a material change or an ultimate employment decision or a significant employment decision. Muldrow also made clear that the covered employment actions are not limited to just, quote, unquote, economic or tangible actions. The court said that the phrase terms, conditions, and privileges of employment is not used in the, quote, narrow contractual sense. It covers more than the economic or tangible. So Muldrow's decision clearly overrules about 50% of the circuit courts, the 1st, 2nd, 4th, 7th, 8th, 10th, and 11th on the standard for a covered employment action. And given that the court goes out of its way to explicitly make clear that those are being overruled, I think there's no question that the Supreme Court's ruling in Muldrow applies more broadly than just the limited fact pattern in Muldrow, which was a transfer, and instead clarifies the standard for all employment actions under Title VII. So what's the takeaway here based on how does this impact DEI? Under the broad and low threshold for a covered employment action post-Muldrow, Title VII arguably extends to employment actions like restricting employment training programs, leadership development programs, or mentoring programs, or sponsorship programs to only employees of certain races or sexes, or selecting employees for those types of programs in whole or in part motivated by their race or sex. Each of those programs is arguably a privilege of employment. And some and all of these types of programs likely could fall under the standalone training programs liability provision under Title VII. Likewise, covered employment actions arguably also include selecting applicants for interviews or placing them on a candidate slate, like a diverse slate policy, motivated in whole or in part by race or sex. In short, here, I think it is a major blind spot for employers to not scrutinize a program that falls outside of that narrow set of hiring, firing, or promotion decisions based on some sort of misimpression that a DEI program doesn't involve a quote-unquote adverse action under Title VII. Finally, point 5, the exception to the rule, which I'm sure we'll talk more about. It is true that employers can consider race and sex, but only in very limited circumstances as part of voluntary remedial affirmative action plans under Title VII. A few points before I wrap up what I'm saying here about the guardrails for those, because again, I think that these programs are very misunderstood. First, it's important to keep in mind that a number of courts at the circuit and district court level have held that the existence of an affirmative action plan is direct evidence of unlawful discrimination unless the plan is valid. So if a company adopts such a plan, it must get it right or else essentially admit discrimination. And labels aren't dispositive. Courts and the EEOC look to functional realities. So courts, including in cases where the EEOC has weighed in amicus briefs at the circuit court level, courts have treated diversity programs as invalid affirmative action plans where a company focused on achieving a desired racial balance in the workforce and took race-conscious action towards that goal. It's also important to keep in mind that to justify a voluntary affirmative action plan, a company needs to have actually passed discrimination, the existence of a significant statistical disparity, or a quote-unquote manifest imbalance in traditionally segregated job categories. And when you're trying to figure out if you have that appropriate data or comparator, you have to make sure you're comparing the right data source to their company workforce demographics. So companies' numbers have to be compared against the labor market for their particular company and job positions, not, as in many popular formulations that I see out there, a company's customer base or their local community in general or the US population. And even with a valid plan, a company can never use quotas or inflexible goals. It also has to be a temporary plan, not for maintaining a balanced workforce. So, in short, and maybe that was long, but to wrap it up, how will we say that? Each of these 5 points, I think, is relatively well established and not particularly controversial. While there might be a lot of confusion about the general public's understanding about what rules apply to DEI, in my opinion, the law itself is pretty clear, and there are some serious implications for some very popular types of DEI programs.
Thank you, Commissioner. A couple of follow-up questions for you. You mentioned the word quota. Are you able to share sort of the EEOC's definition of quota? I know there's published guidance on it, but is there anything to be taken from that post-SFFA that is of note?
I think it'd be more practical for me to answer in terms of how it may function, because again, labels aren't dispositive. You can say that something's a goal versus a quota. The question is, how is it actually operating? If you have a number that is deeply mismatched with your labor market, and you are bound and determined to achieve it, and you make clear at the corporate level that you will achieve it, and you will incentivize your executives to do so, and you'll incentivize them via monetary penalties or bonuses, sometimes to the tune of millions of dollars, that's a quota. Just practically speaking, it is a high-risk possibility that that is going to be deemed a quota because you are doing everything in your power to make sure someone achieves it. So that's my functional definition of a quota as it applies to what I see in a lot of DEI contexts.
Thank you. And understanding that you are constrained by confidentiality, is there anything you can share as it pertains to any new types of claims or charges or increased activity in any particular area post-SFFA in terms of EEOC charges?
Not really. The EEOC releases substantive charge breakdowns. We've taken a rather long time to do that and finally have released our fiscal year 23 substantive charge breakdown. So that'll show you like how many are by race or sex or disability, but we never break down which races are filing. So I couldn't indicate that, but you can certainly go and see whether or not our race claims are up, and I think they are somewhat. Certainly as a general observer of what is happening in the public space, I obviously am seeing pretty much a case every week, it seems, in this space. So it is obviously a fairly active one.
Great, thank you. So you mentioned something else, Commissioner, regarding employers potentially voluntarily setting up an affirmative action plan. So Professor Yalnowski, could you flesh out some of the key considerations that you suggest be taken under advisement when adopting these types of programs, an affirmative action program or a corporate DE&I program and some of the considerations you might keep in mind?
Yeah, sure. And thank you so much for having me. It's great to be here and great to be on the panel. I'm going to answer that question in a, I wouldn't say indirectly. I'll get there. But I have PowerPoint slides, so I gotta. They constrict me. And by the way, I teach for a living, and so I'm used to people not paying attention or walking out or whatever. So the 3:30, 3:45 thing doesn't really faze me. So let me
Please don't walk out. Please stay.
Yeah. It will faze others who are probably used to being listened to. I think for sure we can say that SFFA, notwithstanding that it doesn't have direct doctrinal impact on Title VII, has been viewed as a call to arms by groups of individuals who really want to get and sink their teeth into woke corporations and their ubiquitous DEIB programs. As the Commissioner mentioned, a lot of these cases are being filed on a regular basis. Post-SFFA, there were cases prior to SFFA, but there's no question that there's something going on out there that wasn't going on before. And I also agree with the Commissioner that notwithstanding that Title VII wasn't before the court in SFFA, that it has probably shut the door on the idea of employers using race or gender preferences for operational purposes. For example, it increases our productivity or it makes our workplace decisions more innovative. If you look at the language from Grutter, the court said clearly student body diversity is a compelling interest that can justify the use of race. And the court said, we defer to the law school's judgment that such diversity is essential to its mission. And so not surprisingly, I think, and perhaps unadvisedly, many employers saw Grutter and said, us too, in employment. And mission statements like this, you can find all over the place. We firmly believe a diverse and inclusive workplace fosters innovation, creativity, and a stronger sense of community among our team members.
You stole my tagline.
SFFA comes along and says, you were so wrong. Pursuing the asserted benefits of a racially diverse student body is a standardless, inscrutable enterprise. You cannot do that consistent with the Equal Protection Clause and Title VI. And so an employer who wants to argue that it can use racial preferences in order to improve the workplace is going to be met, I suggest, with that kind of reaction from those kind of people in that particular place. And we agree on that. Now, I do want to spend a couple of minutes on the cases that Commissioner Lucas referred to pre-SFFA, in which the court did say that employers under Title VII can give a limited preference to applicants or incumbents based on race or gender to reduce a manifest racial or gender imbalance in a traditionally segregated job category. Those cases have not been overruled. Those cases decidedly are not based on a finding that the employer had itself engaged in discrimination that created the manifest imbalance. To the extent the court talks about remedies in those cases, it talks about remedies for the imbalance, not a remedy for discrimination. The statistical data that the court said was sufficient to permit the use of preferences was about as inexact and back of the envelope. I see Dr. Zhang in the back of the room, an actual PhD. The Supreme Court would send chills down your spine. The court said 1.83% of the skilled craft workers in the Weber case were black. The local labor force was approximately 39% black. Good enough. In Johnson, the court says no women were employed as craft workers. The relevant labor force was approximately 36.4% female. Good enough. The court was explicit that, an employer need point only to the manifest imbalance, not to even an arguable violation of Title VII. So those cases are out there, and there are lots of manifest imbalances out there. Employers haven't set up their programs in light of Weber and Johnson. Weber and Johnson have sort of been put into a remedies category or are viewed sort of as zombie precedents. But I think the court's going to have to deal with them. I have a hunch as to what they'll do, but those cases exist. And we know that there is still a lot of black-white occupational segregation in the country. It has not decreased substantially since the 70s, and that impacts the black-white pay gap, which we heard about this morning, which has actually increased since the 70s. So, specific examples close to home. Do we see these manifest imbalances as we walk around the world, or are they super rare and exist in the South? 2021 American Law Study, 200 of the largest and highest grossing American law firms, 16 had 0 black partners, what Justice O'Connor called the inexorable 0. If you got 0, you can use an affirmative action plan. No Ivy League law school has ever had a black dean. So I have good and bad news for NYU. You're not an Ivy League law school. You do have a black dean, which is outstanding. 2 of the country's most prestigious law schools, both located in New York State, have never had a woman serve as the dean of the law school. And Cornell and NYU, you know who I'm talking about. Don't be misled by the portraits that you see in this room. That is Judith Kaye, and not a former dean of the law school. So, is it really the case that when NYU was looking for a dean, it violates Title VII for somebody in the room to say, you know, we should put her in the pile because it would be a good idea for us to consider having a woman as dean. Maybe, but worth considering. So now to answer your question. So even if SFFA maps pretty closely onto Title VII, it's really important to realize what SFFA doesn't talk about. SFFA talks about consequential racial preferences, preferences that made a difference regarding applicants to the law school and the University of North Carolina. Here's how I think of it. Everybody's got their own little chart for thinking about DEIB programs. An organization has a mission, and a DEI mission, and it creates programs. And there are a bunch of programs that fit under that umbrella. The risky ones, the ones that SFFA specifically talks about, are the consequential preferences. So there have been some lawsuits brought against law firms that had diversity fellowships that were reserved exclusively for black applicants or black law students, students from historically underrepresented communities or LGBT students. Those law firms were sued. In one case, the EEOC made a rare reasonable cause finding, and those cases are correctly decided. You cannot have a set-aside. That's about as clear as it gets, and I think employers have gotten a little lazy in thinking about what is permissible under Title VII. I wish SFFA hadn't come out the way it did. I particularly wish some of the words that were written by many of the justices in the majority had never been written, but it is what it is. But I think all that really needs to be pruned, and this is every employer's decision to make, are the programs that have consequences based on race or sex, unless Weber and Johnson survive and employers are willing to cop to the imbalance and create an affirmative action plan. I'll stop there. Thank you. And sorry.
No, thank you. So we're hearing about these lawsuits. It started with the law firm scholarship programs and diversity programs that you heard Professor Yalnowski talking about just now. So we've seen a lot more activity, the Fearless Fund, Section 1981 challenges. We've seen even shareholder derivative suits, the law firm that was sued just last Monday. So they continue to come, even though we are almost a year past that decision, and it hasn't slowed down. Obed, understanding and hearing about and watching all of these risks and these legal challenges, where is there a place for DE&I? Is there a place for DE&I? What does that look like from somebody who sits in your seat in your organization?
It's over, it's dead. No. Since Professor Yalnowski take my tagline around DE&I, right? We do know as organizations that it does foster greater collaboration, greater innovation. It drives business results, and so we know that diverse teams, diverse panels are going to get to better decision making. When you went to put this panel together, right? You looked at diversity of thought, individuals from government, from academia, from business. Whenever we have a collection of individuals that come from different perspectives, it is going to cause us to be smarter, it's going to cause us to be sharper, it's going to cause results. But in the wake of the time that we're sitting in today, I think a number of organizations are taking some different positions. I put them into three categories. One is full throttle, nothing changed. right? And then I would say the most, probably the most thoughtful organizations on diversity, equity, and inclusion historically are ones that had not focused purely on representation, right? Because it does not matter if we look different and we sound the same, right? That does not give you the benefit of diversity, of thought in mind, right? So when you're solely focused on the representation, those are the organizations who got it wrong. And then they have to step back and then look at the law and then change the approach in which they're operating. So I would say those organizations where in equity, inclusion, thinking about how to get the best out of everybody in order to solve problems, to build products, to build solutions for their customers that's reflective of a diverse world, those individuals stay in the full throttle, keep going. I think the large majority of organizations are in the recalibrate. Let me think about some of the terms I'm using. Let me think about the programs that I've created. And in some cases, organizations may have gotten too shorthand or too lazy in looking and building programs and so forth. So it's completely, we do know that individuals from different backgrounds may have different needs and have a need for community. But it doesn't necessarily mean that everyone who's in the same race or the same gender have all of those same issues. So being able to create environments or communities or employee resource groups that is for individuals as well as for allies or individuals who want to support is fine, right? It's a matter of understanding that there's a community of needs and being clear that this doesn't exclude any particular population, but anyone who wants to be part of is part of the solutioning for that particular constituency or community. And then I would put the third category of organizations when talking to a number of my peers is that those who've completely stalled and stopped and said, let's take stock, given where we are, and then let's figure out, and then let's build a new construct around DE&I. So I will put most organizations into the middle section of let's look at a number of our programs and then how do we tweak them. And then on the far edges are those who are full throttle, who has been thinking about in this particular way for a long period of time. The last thing that I'll say, or the third point that I highlight here, is with regard to the impacts of SFFA in the long term. I do believe that that individuals who are sitting in my seat in corporations all around the world do recognize that there could be long-term pipeline or long-term talent implications to the decision that was made. So while there isn't a direct correlation to the employment, there is from a sourcing standpoint. So we do have to think and work smarter with organization, with the use of things like joint programs with universities, things like thinking about skills-based hiring. So the reality is, in this country, only 33% of the population have a bachelor's degree, right? So, and then we have a shortage of talent. So looking at jobs, there's a number of jobs in organizations. In my last company, you know, we moved from a place where all jobs required degrees to 90% of them didn't require a degree anymore. And then so removing barriers, dumb barriers in job descriptions, where it then creates limits to individuals who can apply for those particular jobs, is a way of making a more inclusive organization and a more inclusive economy, right? Because by placing in those types of barriers, it excludes populations. And when we know, and if we look at race itself, right, in this country, while a third have degrees, it's about 20%. It's 17 to 20% if you're talking about Black or Hispanic candidates who have a four-year degree. So being clear, so looking at the pipeline implications and then looking at what are ways in which to build more inclusive environment, more inclusive hiring practices, training practices, et cetera, is key and critical. Going back to Professor, that comment around if you were in the boardroom and in looking at the dean for NYU, and they said, I think it's a good question to put on the table. I think the question would be, what is it that we've done as an organization, and this, you can take this into any boardroom, what is it that we've done as an organization to not prepare any women for these jobs? How do we have, 30, 40%, 50% representation at the entry level, but then when you get to managerial levels, you don't have that same representation? So what is it about our processes? What is it about the way in which we select that has created the barrier for that? And that's what you go and address, and that is completely legal.
So this is a question for you, Obed, but it's really an open question for the whole panel. So for anybody who has an opinion on this, feel free to jump in. But should all companies have some DE&I programming, some DE&I mission or initiative? All companies? And if so, why? Are there certain companies perhaps who might, I get this question, I'm a management side lawyer, I get this question from employers post SFFA. Well, look at our stats, Amy. Our workforce is highly diverse already. We don't have any work to do on the DE&I front. So is there a risk in doing absolutely nothing? You identified, Obed, one of the categories of the types of companies post SFFA who say DE&I is dead and they ditch it all. Is that a better place to be ever? Are there risks there?
So my own opinion is absolutely not. I mean, there is certainly, because that's not holding to what does diversity, equity, and inclusion mean, right? So you may have representation that looks like the census, but do those individuals feel like that they can contribute in the organization in the same way? Do they feel like in order to be heard, they have to sound like a certain prototype, right? So from that perspective, there's always an opportunity. And even in situations where your demographic may look better, are you discriminated or is there opportunity to go the other way? So there is opportunity. And if we know that in study after study, and in the most recent one was the McKinsey study that shows that diverse and inclusive organizations are 21% more likely to have stronger profit, outperform their industry, then it makes business sense. So not only does it make sense from a morals and a societal standpoint, it makes business sense. And a number of our organizations, if you take, for example, I was on the committee, the advisory committee for the Department of Labor on apprenticeships, and in one of the areas where we identified a significant gap in this country is around cybersecurity skills, right? So we have a shortage of about 700,000 cybersecurity experts. So if you aren't thinking about inclusive hiring practices, then you're just going to continue to have skills gaps, right? So closing off or not thinking about certain populations just reduces your talent pool. So it just makes business sense, it's societal sense, and it makes more inclusive economy.
I'll offer a counterpoint. I think that the terminology DEI is deeply fraught, and I don't think you have to have a DEI program. But you must have an equal opportunity program, and a robust one. That's required by the law. There is no requirement to do DEI, but there is absolutely a requirement to do robust equal opportunity, not a tired, dated one that is a check-the-box attempt to remove liability, where you just have an EEO policy that says, we don't discriminate, and you do nothing. That's not what equal opportunity requires. You do need to remove barriers. And I think that many employers, by doing lazy, high-level virtue signaling, paint by numbers DEI, have masked discrimination. And good numbers, good, painted at a very high level and done by basically something you can sell to an investor or to an activist or whoever it is, don't actually allow you to see where you have serious barriers to equal opportunity or you have active discrimination or harassment. Justice Thomas, when he was chair, wrote about this decades ago, and he said affirmative action is actually the lazy solution because it is vastly cheaper for an employer to have a prospective thumb on the scale for hiring than actually dig through its workforce and look at its hiring and look at its positions and look at what's happening and remedy the discrimination and harassment that it has. It costs a lot of money to pay someone who has actually suffered discrimination and harassment. That is more costly, but it is also the right thing to do. It is the morally right thing to do, and it is the legally right thing to do. I will also push back on the business case. I don't think the business case matters because what if all these studies, which I will actually, if we had a longer debate, I would push back on. But let's say they're all wrong, and it actually turns out that a homogenous workforce is vastly better for business. Should we just have an all white workforce? All of these arguments that come from the business side of things can be flipped to the other direction to negatively harm traditionally discriminated against populations, however you want to formulate that. The answer is the law demands equal opportunity, whether business it is good or bad for business. The law demands no discrimination, whether it is good or bad for business. If you have a discriminator in your workforce, you should fire them, even if they are the best business producer in the world. And if you only are looking at top level numbers and it looks pretty on your company a balance sheet or your brochure, you actually haven't complied with the law. So that's my, maybe perhaps a little counterintuitive, but I think we land similar places. I think it's just coming maybe from a different perspective in how we phrase it.
I have a thought too. I think, when I think what's special about this country, what makes me proud of it, it is its diversity, and it is the fact that people want to be here from all over the world. And at least when I was at OFCCP, and I talked to our economists, and even just looked at it myself, I often, I came to the conclusion that one of the biggest drains on our economy is our failure to fully utilize our workforce. And that's why diversity is important, because when I see a picture or I see a company or I see executives that are 80% male, 20% women, what occurs to me, knowing as a professor of law that over half of my students are women and they do just as well as men, that it really should be 50-50, and that the fact that it's not 50-50 means that something's happening where we're losing a lot of really talented women, and it's bad for the country. And that's the issue. The underutilization of minorities, women, people with disabilities is bad for the country. We're failing to fully utilize our workforce. Now, how do you address that? I do think every company should have a DEI program. But I agree with Andrea, with Commissioner Lucas, that DEI as it's being discussed politically is not what I'm talking about. And it's probably more like Equal Employment Opportunity Program, as she mentioned, and as you mentioned. I think that every company should be auditing its workplace, doing a pay equity audit every year, auditing its hiring, its selection rates to see if there's discrimination occurring, auditing its promotions, using statistics. If you want to set a diversity goal for a particular underrepresented group, then show that there's a 2 standard deviation disparity. There's a lot of companies that do it. It's quite easy. Go in there and assess your workforce, get the numbers, and then take the action you need, because what you're really doing is you're addressing discrimination. A pay equity gap, if you've controlled for all the factors a company uses to set pay, is likely either disparate treatment or disparate impact. It's an unexplainable disparity. You're paying women less than men for no reason that can be explained, which means that you should fix it. Now, I'll tell you, a lot of companies, in my opinion, they have these glossy folders, they have these great DEI programs, they're very political sometimes, but what they don't do is put a lot of money into addressing pay disparities. They don't put a lot of money into programs that make their workplace somewhere people want to be. And that's what I'd like to see, more of that. And so yes, I think every company should have a DEI program like that. Not preferences, not quotas, not reductionist thinking, but real equity. And with the NYU issue, if NYU is thinking about a dean and hasn't considered a woman, I would think that they're discriminating. I mean, I say that respectfully, but I would think that. Why are you? That's the question I would ask, not tokenism. Let's throw a woman in the mix. I would ask the question, why have we not considered a woman? What's happening here? Because it's probably discrimination or a stereotype of who the dean should be. And that's something you can't take action about.
Commissioner, you noted a question about whether these types of programs or initiatives should still be called DE&I. And I've had the same question as well and the same conversation with employers. And I like your framing of it as equal opportunity, which has always been the law. Another way we have tried to frame it is the focus on the I, inclusion. And if you have inclusion as your key focus, you end up with a lot of these same programs and mission statements, affinity groups, things of that nature, because again, it is equal opportunity for all. So, Craig, what are you seeing? What can you tell us about? This panel is covering not just DE&I corporate America programs, but Executive Order 11246, federal contractors, OFCCP regs. This is your space. This is your area. What can you tell us about these types of things post SFFA?
Well, I said what I came to say, actually. But I thought about that. But OFCCP, I love OFCCP. And there's a lot of representatives here from OFCCP. And we saw the Solicitor of Labor who works with OFCCP. Here's what I have to tell you. If you're a federal contractor, you still have affirmative action obligations. It's not the same type of affirmative action that's in higher education, but it's the type of affirmative action I just talked about. You don't have preferences or quotas. What you do is you use, and those who are federal contractors know this. I think non-federal contractors should consider this. If you really want to have a DI program, do the analytics. Determine if you have underrepresentation in different job groups based on EO1 tabulation data. And if you do, try to determine why that's happening. Are there stereotypes in place? Are you not recruiting diverse groups? Are you only doing it by word of mouth? Is there some sort of affinity bias occurring? Figure that out. If you look in your executive group and you don't see that there are minorities, or you see that women are significantly underrepresented, then take action. But the action shouldn't be, you know what, the next 10 executives are going to be women or minorities. That would be a quota or a preference, and that would be unfair to the men who are trying to also advance in your organization. Every individual is diverse in their own way and deserves that opportunity to try to advance. What you're doing, though, is making sure that the women in your organization who may see that everyone there is a white man and they never advance women, that they don't leave or they don't sue you for discrimination. You need to take that and also so that you get the talent that you've been building up and that they stay with you and you advance them, that's the business case. But the point is, take that action. Make sure that you're assessing your promotion pools. Look at who's making the decisions on promotions. Are there established standards, or is it a tap on the shoulder? Are you making sure that those decisions, are they being made on the golf course, or are they being made at dinners where it's only men around a table? Or are they truly diverse groups making these decisions with everyone having an opportunity to be included? Anyway, that's what OFCCP affirmative action is. There's also the components related to their audits, which is more non-discrimination. They do audit the affirmative action plans. But typically companies aren't that concerned about that. What they're concerned about are the pay and the hiring audits, and sometimes promotion audits, looking at race and gender and seeing if there's disparities in hiring rates or in pay rates, and also seeing whether that's tied to a workplace policy or not. Is it disparate treatment? Is it disparate impact? Looking at now the role of AI, all of that. Federal contractors, if they have a good program, are looking at all those things and auditing their programs every year. That's why, I've seen studies that say federal contractors do the best in these areas because they're very attuned to it and they want to keep their federal contracts, and they typically have professionals who care about these issues and understand how to do it right. And if I may say, with OFCCP here, one very positive statistic is that, OFCCP, when it's looking at whether there's discrimination or not, among the federal contractor population, they find discrimination only about 2 to 5% of the time. Most companies, and even then, it's often a disparity based on disparate impact, and it's settled. They only bring a case about 1% of those 2% of the times. And you know what? That's a good thing. It shows that companies are working with them, they're trying to get it right, they're taking proactive action, and that's what we want. I'd like to see that expand beyond OFCCP, to be honest, because I think that other companies could benefit from that sort of approach. And I want to make sure that that we have.
Yes.
So
I am
done.
heading to Professor Frakes now because he has a very interesting paper out there, which he has written about incorporating research on race with regards to the quality of medical care. So the paper is called Racial Concordance and the Quality of Medical Care, Evidence from the Military. So Professor Frakes, I read your paper and I think it's incredibly interesting and I think has some overlay with some of the issues that we're talking about here today. So if you could please share that with the group.
Yeah, I think the dialogue so far is, to some extent, nicely situated it, because at least one thing has come up is a question mark over, over the business case, over the diversity rationale. There's a little bit of a disagreement here, and I do agree that it's actually challenging to sort of, in a convincing way, go to the data and actually sort of make the case. We're not generally sort of, doing experimental designs out there where we're randomizing the diversity of the workforce, the diversity of the student population, and then actually testing this case. We're sort of working with sort of existing sources of variation, and we don't know really what we're picking up is just correlation that could be explained under other stories, or actually sort of a causal connection between the diversity itself and the outcomes that we're ultimately looking at. So, and this kind of justifies my world as an empiricist to actually try to identify these interesting questions, but to come up with strategies to actually kind of move from the correlation ultimately to the causation. So I'll talk a little bit about the work that I've done, not across all, I can't give you a sense of sort of all workplace settings, but in the physician context. And I would say even a little bit more specifically, I think how I really phrase the question that we're asking is, when we diversify the physician workforce, when we make the physician workforce more representative along racial lines of the underlying population, do we see reductions in racial health disparities? Because there's a big literature documenting racial health disparities across many dimensions of healthcare. We know that, and the paper is admittedly focusing more on the Black experience, thinking about the disparities between Black patients and non-Black patients. We know that the percentage of Black physicians in the U.S. is way lower than the percentage of Black Americans. So the question is, are these two facts causally related to one another? And the literature has actually just not come up with a convincing way to actually sort of connect those two and actually to really give us that answer. I think the closest studies have actually asked a little bit of a more specific question, which is, when there is racial concordance between doctors and patients, do we see certain benefits? And there could be a number of mechanisms underlying that. We could see enhanced trust and communication when Black patients are being treated by Black providers, and that could cause the Black patients to adhere to their medications more and to ultimately sort of experience better outcomes. So there is a literature on that, and most of that literature is actually at the kind of the correlation level, and there's actually sort of a number of them that I think we're moving and coming up with better designs to sort of move towards causation. One of those papers is actually sort of referenced by Justice Jackson in the SFFA dissent. And really how our paper, doing this joint with John Gruber, how we started is we really wanted to kind of build on that specific question. And because we had some problems with their research designs, I'll give you a brief sense of our strategy in a second. We tried to build on it, but actually I came to sort of to discover, I think that there's another problem with those studies. They're really asking a more specific question, and they may not be capturing the full gains that could come from diversifying the physician workforce. So think about what would happen when and think about we're in a particular community and we increase the availability of Black providers. Yes, we may see a higher number of concordant matches between Black patients and Black providers, and we could see certain gains from that. There could be a number of spillover effects as well. So it could be that even the Black patients that are seeing the white providers may witness sort of greater sort of Black physician involvement in the community, and that may actually, generate greater trust in the medical, in the medical infrastructure as well, and they could then therefore sort of lead to certain trust gains with their discordant providers. And I can tell related spillover stories as well. And so I think what was missing from this literature was actually a research design that went directly to the question of, when we sort of increase the diversity of the physician workforce, do we see sort of reductions in disparities? And this is not going to be a technical talk, so I'll just sort of I'll quickly say that we turned to the military setting, and John Gruber and I have been doing a number of studies on the military health system. And the basic idea is we're kind of leveraging the fact that there is heterogeneity across bases in the availability of Black providers, and we're sort of following patients with chronic diseases as they move across bases. As you know, there's a lot of mobility in the military context, and to actually give us what we call hopefully plausibly exogenous shock. So it's not truly experimental, but it's quasi-experimental in the availability of Black providers, and we're seeing how sort of Black relative non-Black patients are benefiting from these moves. And I'll just the punchline in terms of the results in the chronic disease context is there's certainly a very strong sort of business rationale, sort of really strong diversity rationale in this particular context. So I think one of our results would suggest in our community of the military health context, if we were to make the physician population there representative of the underlying military population, we would see a reduction in the mortality gap for patients with chronic diseases that we're studying at about sort of like 30% relative to the mean mortality rate. So real substantial gains. And I'll stop there.
Yeah.
That's fascinating.
3-0.
30% relative to the mean, so it's so not like 30% overall, sort of like lower probability of dying, but that's still a huge gain.
Still big.
Yes.
It's a big deal.
There are other measures to obtain the same effects with racial concordance. I mean, part of it is getting the patient to believe in the medicines. Now, maybe there's a communication gap. I find talking about there is a communication. Maybe to the me. What I've said. But there is that problem. Maybe mitigate a substantial strain without having the kind of racial preference around the
Yeah, and so this is.
Can you repeat the question? I think people.
Yeah, and so to some. Yeah, and I'll restate it in a way while answering it as well. And so, one virtue of what we're doing is, again, like our strategy goes right to the heart of, like, if a policymaker wants to know, yeah, if I do make the physician workforce representative of the underlying population, on that, what are the gains I'm going to see? And we could sort of nicely get it at that. But I think what Sam's asking is, well, there could also, if I could, with my analysis, unpack the mechanisms underlying that a little bit more, the results could also speak to some policy initiatives that go beyond just diversifying the physician workforce. So for instance, if I think what I'm picking up with my analysis is actually something about enhanced trust and communication, that could also speak to the possible gains that we can get, maybe not necessarily from diversifying the physician workforce, but having sort of cultural competency training for all physicians. And so, yeah, so one thing I've sort of skipped over is some of our work tries to not just give the main result, but to try to dive into the mechanisms. And we do, through certain strategies, we do think that what we're picking up is a lot about sort of trust and communication. This is, yeah, we sort of, we leave it short of saying for sure what should be the optimal sort of package of policies that we ultimately consider. But yeah, it's a great question.
Okay, so for our panelists here, before we open the floor for any Q&A time, any final comments from panelists that they'd like to share?
I'll make one quick one. I actually think this is a good thing. That, you know, for a very long time, I think what employers were doing and what the law permitted or required was there was a mismatch. Employers were predicting. It was very hard to predict what Grutter meant for workplace DEI programs. I think thinking hard about what you're trying to do and using steps that don't necessarily involve the use of preferences. I'm not saying there should never be the use of preferences. I still believe in Weber and Johnson, but I think it's good for employers and those who support workforce integration to be thinking hard about this in a way that maybe we haven't for a while.
I also think that we're in a good time to be reflective, because if some of the programs, and then as the commissioner mentioned, some of the lazy programs or the programs in name were effective, then we would be in a better place today. And the reality is, for decades, some of these programs have been in place, and it hasn't substantially changed the workforce, particularly at the most senior levels. So it's a good time to reflect and then audit, as Craig mentioned, looking at the data to say what are the things that are driving in and how to make true progress, and then ensure that we don't have discriminatory actions, practices all throughout the pipeline within the organization.
And I would just add that, most of the programs do focus on race and gender, and I think that's mostly what we've talked about. And that's good, they should. Assuming there's no preferences or quotas, there's still work to be done in our country in that regard. But include disability, add the A for accessibility. Include other protected classes, LGBTQ+, religion. Have a broader view of diversity, I would advocate. And, remember that discrimination still exists. And I think most of the panelists here have said that. Most of the claims are still being made by women and minorities related to discrimination. So there's still work to do there. You don't need preferences or quotas. What you need is to address discrimination and eliminate it, and then a lot of this will take care of itself.
Okay, looks like we have about 4 minutes for questions. Yes.
Sorry, this is my second question today. And that makes me, I think, the second for the most frequent question. So, good. Oh, thank you. Testing. Okay. My question is just again, sorry, not a lawyer. I wanted to expand on the sort of question about putting your money where your mouth is and really making it inclusive as far as pay equity and other things. So on the HR side, practical question, annual compensation reviews are pretty resource intensive. Performance reviews, like the prior panel mentioned, data is not always really great. Another practical challenge is you may not have a large self-identifying disabled workforce or self-identifying LGBTQ workforce. You might not even be collecting that data. So in practicality, how do you really prevent some of these issues? Or if you do see inequities going on, it's one thing to correct it retroactively. Oh, we noticed this from the pay equity analysis, but there's a lot more to this work than just pay equity analyses. We've only talked about pay equity analyses. I'd like to hear a little more about other ways that people can do the work proactively, preventatively, et cetera.
So there's a couple, I do think we have to do the work as organizations to put in the right systems in order to then be able to take corrective and then also there's leading indicators as well. So if you take the conversation around performance and then you look at an organization, it says, okay, are women, minorities getting performance reviews at the same rate? What's the output of the performance reviews? Why is that the case? Are there concentrations into certain locations with certain managers? But going through, we first have to build the tools and put in so that we can have the data and then look at the data and then say, are there patterns in the data where there's places that we need to go and address? So I would say yes, while it's not easy, by way of the tooling and things like that, but we do have to put those foundational tools in place and then do the hard work and looking through the data to make sure that we root out those things. And then as the commissioner said, if it ever comes down to a person, you got to root them out of the organization. And my opinion is you do it loudly because then it actually shows, it actually helps an organization understand what is permissible. It's not enough to just have fancy values or a code of conduct if you don't live by it. Most organizations, most large organizations are going to have some infraction of some sort. I do think cultures in an organization is built by how you respond.
Yeah, and I would add, for federal contractors, they do have disability self-ID, and also, and I self-ID, and they have veterans self-ID. They don't have LGBTQ+ self-ID, although If a company does it for the benefit of its employees and anonymizes it, it's something that could be done too. I do advise companies, even that are non-federal contractors, who do ask those questions and then anonymize the information, ask questions related to that, and then, basically have surveys where they can assess whether different groups, based on their background or experience, might be having different experiences. And through that data, they then could take action to address it, because it can often be used to identify barriers. So I strongly support that. Also, 100% you should be doing not just pay equity audits, you should be doing selection audits, adverse impact analyses under the uniform guidelines. I know the EOC cares deeply about that. And you absolutely should be doing those things. It should be a comprehensive approach.
Sam?
2 points. One, I don't think that the Supreme Court has rejected race-conscious hiring. What's your views on that?
Title VII rejects it. The Supreme Court doesn't need to reject it. Title VII already rejected it.
The Supreme Court has twice said it's okay.
Wow. Weber Johnson, highly
Making a
recommended.
separate point, Michael, that this
General
Supreme
point.
Court has not changed. There
Correct.
is a stable majority, 3 so-called liberals, Chief Justice, and Kavanaugh. They do not, with that opinion 10 times. It's true, it's not an absolute model of clarity. It's not rejecting race-conscious programs. Here I agree with Craig and with you. It needs to be based on a real analysis, which you're underutilizing the available workforce. The executive order approach, which, by the way, O'Connor had adopted in dissents. In many of the Title VII cases, I wrote a brief on that theory, and then she went off on a different angle because she thought it was necessary to save the nation. There was a completely different angle. Going back to the notion that you have to prove you have a problem.
Yeah, Weber and Johnson are narrow. They just are, and you're not going to get a drop more. There's no way, as a practical matter, that the Supreme Court is going to broaden Weber and Johnson. They're only going to tighten it, and any case attempting to challenge or push that is going to lead to them either being removed or restricted further. So you got to decide whether or not you want that bargain. As I said in my opening, if you have a voluntary affirmative action program, it is direct evidence of discrimination. Oh, you need to get it right. Maybe you can in some situations. I think I'm much more skeptical than the professor is about how often you can do that. But certainly you need to do it in a competent manner. To Craig's point, companies do in fact know in context how to do data analysis. And what I have heard from many employer side, stakeholders, and certainly is consistent with my experience, is that many employers kind of forgot all of that data analysis that they were doing in the OCC space when it came to DEI. And so they set a lot of goals that had nothing to do with the numbers that they had in very parallel things.
That's the
that too is evidence out there of discrimination, because right now you have a data source that shows significant disparity in the goals that you were setting for yourself in a DEI context versus the goals that you were acknowledging to the federal government and OCCP. That is a dangerous place to be in.
Yeah, if you're doing the audit, pay equity audit's the easiest because it's probably the most accepted. But if you go in there and you find a disparity based on gender for a particular job group and you identify those individuals are being paid less, you can increase their pay. And in a sense, that is gender conscious or race conscious, although you're increasing their pay because they're underpaid. You're remedying it. It's a remedy.
Yeah. Motivation matters tremendously.
Remedy is a big
The
deal.
direction that you're approaching it matters tremendously. If you are remedying discrimination, that is very different than race-conscious action from the other direction in order to create preferences kind of perspective. I do think motivation and the angle at which you're approaching things can make the world a difference.
Thank you, panel. I just want to make one comment about something, about whether NYU's law school should have considered a woman. The dean of NYU's law school reports to a woman who's the president of New York University, and who, among other things, is a lawyer. This was a great discussion. Thank you very much.